Good morning, everyone, and welcome to the Utah Court of Appeals. I am Judge Oliver, and I'm joined this morning to my right by Judge Christensen Forster and to my left by Judge Luthi. We have one matter set for oral argument this morning, and it is State v. Hernandez-Rivera. If I could have counsel make their appearances for the record, please.
Good morning. Douglas Thompson, representing Felipe Hernandez-Rivera.
Good morning.
Good morning. Daniel Boyer for the state.
Good morning to you as well. I see we have 11 minutes on the clock, so you've reserved 4 for rebuttal. Is that correct?
That's right.
All right. I know you're both far experienced in being here, so unless there are questions before we begin. All right, Mr. Thompson.
Good morning, counsel. May it please the court. I represent Felipe Hernandez in this case, and I'd like to focus on 2 of the 4 claims that are made in the brief. Of course, I'll answer questions with respect to any, but given the limited amount of time, I'd like to focus on the first 2, characterized as the preserved arguments. And to start right out, I'd like to talk about the idea that the district court judge made sort of a fundamentally flawed analysis of Rule 412. Because as the rule is written, this is a scenario that perfectly encapsulates this situation. This is the reason this rule was written, in that the state presented evidence, physical evidence, to bolster the claim of the victim in an attempt to demonstrate that there is this physical evidence to show this act occurred. This is exactly why the exceptions to 412 apply, and why the protections generally afforded under a 412 analysis are not important, don't have any persuasive weight in excluding this evidence. This court's well aware the allegations were quite old at the time of the trial. Nearly 2 decades had passed between the alleged incident and the time of the offense. And in that scenario, the credibility of the only 2 people who were present at these incidences was of most import. Of course, the state understands that, and they understand that in these cases they have to demonstrate that their witness is more credible than the defendant's, right? And in order to do that, they oftentimes try to bring in forensic evidence. And they did that in this case. And forensic evidence is very, very persuasive. As the state noted, and as the state below noted, the CSI effect matters, right? It matters that the state can bring in this persuasive, unbiased, unchallengeable evidence to demonstrate that the act occurred.
I have a question about a particular part of the court's analysis on that. And it relates also to an argument you made in your reply brief, where you pointed out that if the victim had come in pregnant, or if there had been clothing with semen, that this is quintessential. You'd want to be able to show who else may have provided that. The court in this case noted that there were reasons why the probative value of that physical evidence being from another person was low. And I've, in my own mind, drawn the analogy that if, in the instance of pregnancy, if at the time of the other potential father, the victim, if there was evidence that the victim had been on birth control pills and that there was a condom used,
Sure.
That would figure into the analysis. And if the physical evidence was a dress with semen, but it was undisputed that they'd been playing tennis, that she hadn't been wearing a dress.
It would reduce the probative value.
It would reduce the probative value. Was the court wrong in considering reducing the probative value based on what was known about the investigation into?
I think so.
Mundo?
I think for two reasons. For one is because there wasn't really a substantive demonstration of that evidence. The judge was just kind of taking bits and pieces from what he had analyzed and heard. It's not as though there was an evidentiary hearing on that testimony, and the investigators from that other case came in and presented that.
Was it disputed? Were those facts disputed?
They weren't conceded, I guess I should say. But again, because there wasn't this sort of full-fledged evidentiary hearing, it wasn't as if the defense actually had the opportunity to do that. That's what I mean, is it felt to me like the court was actually grabbing that information after the fact in order to support its decision, as opposed to actually confronting that question. So that's the first reason I think that that's not a very persuasive argument from the court. The second is that there's lots of other reasons why those justifications could be undermined. I mean, for example, the other information the court knew about this other incident at the hotel is that she had spent days there, as if there was no opportunity for her to gather that evidence and put it in the baggie and keep it for all those years or all that time afterwards, because there had been this investigation after the fact, and the court is just sort of just without any basis, accepting this one very narrow version of the facts and taking that opportunity away from the jury and preventing the defendant from making persuasive arguments, as I think we've tried to make in the brief, about what the defense would have been able to say about that hair and its relationship or potential relationship to Edmundo. Especially given her very different perspective on these two relationships, right? She's characterizing her relationship and these incidents with my client as unwanted and against her will and all of this. And the relationship with Edmundo is something that she cherished, something that she thought was very special. And when that's characterized in light of why she said she saved the hair, it would be very persuasive, I think, to the jury to hear that, to say it's much more likely that she would have saved that hair from Edmundo, from that experience she had with Edmundo, and made that something very special. It's also really interesting because of an argument that I want to make about prejudice, because of the way the prosecutor characterizes the evidence and sort of the limited DNA evidence in his closing argument. So, for example, in record page 2831, the prosecutor is arguing in rebuttal. He says, it's a man's hair and it's a woman's touch DNA. Again, that's maybe a stretch from the evidence that's actually presented. He's maybe going a little further than he might have been able to, given what the limits of the DNA evidence at the time. But this is his argument. It can't belong to more than one person. He's talking about the hair itself. It can't belong to more than one person. The hair's got to belong to somebody. Now here he is exploiting the fact that there's only one somebody to talk about, only one male somebody to talk about. And this is really, really critical when we talk about the purpose of 412 and the exception, the explicit exception to that. I mean, that would be like in your hypothetical example saying, well, there's semen on the clothing. The semen didn't come from her. It couldn't have come from her. Semen doesn't come from women, right? All the while knowing and understanding that there's someone else it could have come from and exploiting that fact with the jury. I mean, that is the quintessential use of the shield as a sword.
Can I ask you to step back just a little bit in terms of the 403 balancing in the context of 412?
Okay.
We all know now that the Supreme Court has said, no extra textual gloss on the plain language of our rules and on, well, mostly our rules, right?
Sure.
And that you argue to a certain extent that the Supreme Court's decision in Boyd, that there is a presumption of inadmissibility related to 412, that we have stepped back from that was sort of a wrongly decided, given what they say now. But is that really true? Because from the perspective that, isn't it up to the trial court to determine, to engage in that balancing? And while the court has to consider all the relevant factors out, as stated by Rule 403, isn't it the trial court that gets to decide what's most important? And here, it seems like the trial court decided that the purpose behind 412 and the unfair prejudice that would result from introduction of this, the mission of this evidence, would really be unfairly prejudicial to Sadie.
I think what's happened and I think Boyd plays a big role in this, is that appears to be in the court's idea this overlap between 412 and 403. When in reality what I think has happened is that they're now separated. There's a 412 analysis, and then every piece of evidence goes through a 403 analysis, right? Everything has to be not overwhelmingly prejudicial, right?
But how can that be true when Rule 412 is specifically designed to address the evidence here? I mean, are you saying there's no overlap between 403 and 412?
What I'm saying is that if you're talking about evidence that is inadmissible or arguably inadmissible under 412, not under the exceptions category, but under the main body of the rule, it is a presumptively inadmissible, right? But once you've cleared that hurdle, and we certainly cleared it in this case, then what you're talking about is Rule 403, and it has a presumption of admissibility. At that point, relevancy is sort of met, and relevant evidence is admissible. And then you have this very high burden to exclude evidence only when it's substantially, the unfair prejudice substantially outweighs the probative value. And the unfairness is sort of the critical idea here. Once you're talking about these exceptions to 412, what becomes unfair, as I'm going to keep repeating this idea over and over, is where the state can beat the defendant over the head with these inferences that would be rebutted if the testimony or the evidence was admitted. So in other words, can anyone think that it would be unfairly prejudicial to the state or to the victim to have their arguments rebutted directly by the evidence they've sought to exclude? And that's the point, is that there may be some prejudice associated with it. All evidence that hurts your case is prejudicial, but it's not unfair prejudice when it is the state using that evidence or the lack of that evidence to try and prove their case.
So it sounds to me, though, that the challenge you're making isn't to the court's Rule 12 analysis, it's to the Rule 403 analysis. Because 412, once you get into the exceptions, is a may. It doesn't say it's admissible. It says it may be admissible, right? And then the other rules come into play. And as I hear you describe it, it sounds to me like the challenge is that under 403, that the court made an improper analysis there because improperly weighed the unfairness and the probative value.
I mean, I think that's right, except to say, just to repeat, that I think the court incorrectly sort of fused the two rules together. But as far as the error that he made, it was under the 403 portion of the analysis, because he did say over and over, this qualifies under the exception to 412.
I want to ask a question about that fusing idea, which may be repetitive, but a different way for me to think about it. Are you saying that once you get into one of the exceptions of Rule 412, you shift to 403 and you don't even think about that you've just come from 412, and under 403 where it says that the probative value needs to be substantially outweighed by a danger of one or more of the following, you have to stick just to the list given in 403 and cannot consider the embarrassment or effect on the victim? The coming from 412 does not allow you to add that to your list of considerations under 403.
What I would say is that embarrassment,
and that may not be the best term,
Okay,
but
so-
the
Invasion
effect
of
on
privacy.
protecting the victim.
so I guess she's mentioned the idea of invasion of privacy. I would
That's
say
the better
that is not a consideration under 403.
And it
Unless
isn't by its terms.
unless it is considered an unfairly prejudicial invasion of privacy. In other words, there are things that would be irrelevant and that would have essentially no bearing on the case. Then yes, I think that could be categorized in the 403 assessment of an unfair prejudice. But when we're talking about things that have already cleared the 412 hurdle, we're in a different world.
So it sounds to me though like what you just conceded is that there could be circumstances where the idea of unfair prejudice, which is language under 403, could include unfair prejudice to the victim?
Certainly. I just think that has to be read in context, especially in the context of the way the case has been presented by the state and by the victim. And as I see it, the state's case in this case, the state's presentation of its case is fundamentally taking advantage of the 412 ruling. The prosecutor over and over and over sought to use the exclusion of the evidence against the defendant.
Was that argument made below in terms of the motion regarding the hair? That the prosecutor is trying to paint Sadie as an innocent, inexperienced person and therefore credible. And so we need to be able to put on the Edmundo evidence to rebut the image of her innocence.
So I think I would say it's preserved sort of sequentially as the evidence comes out. Before the trial, during the motion practice, it's not clear exactly how the state is going to present that evidence, and it's not clear how they're going to make those arguments. So it's preserved in the sense that the judge has the argument, the idea and the rule and the exception before the court. And as the testimony comes on, defense counsel objects and renews the objection over and over and over again. Each time, essentially, the state puts another brick on the wall. And I would say from the perspective of preservation, we have maybe a dozen instances where defense counsel is repeatedly telling the judge, they continue to do this. They continue to make things actually worse. And so, yes, I think from the perspective of preservation, it's preserved as well as it could have been as the case progresses, as the evidence and the arguments changed.
Can I ask you though then about your ineffective assistance of counsel claim that basically defense counsel didn't take as much advantage of and didn't keep pushing the trial court to allow the evidence on cross-examination of the mother.
Sure.
When they were talking about don't you
journal.
remember that? No, don't you remember that when your daughter? Oh no, it was I can't remember which one, but that your daughter
It's gone for 2 days.
Was gone for 2 days, and you can't remember that, but yet you remember the counsel didn't really keep pushing that argument, and couldn't it be reasonably strategic that defense counsel knew that the court wasn't going to allow this, and that ran the risk of angering,
Sure.
the jury and mother and.
I mean, I think my first answer is that the ineffective assistance of counsel arguments in this case are argued sort of in the alternative as a backup. But I would say that there is a certain point in the case where it does appear like defense counsel kind of has to concede the judge just isn't going to give me any. I mean, I have given him way more than enough reason to reconsider his earlier ruling. And at some point I just have to call it, and it is preserved. So I think there's a balance there.
Okay.
And very often when I make ineffectiveness claims, it's in this fashion where I say to the court, I think my preserved claim is right. But if you disagree with that, that means you are disagreeing about preservation. So then let's talk about how this unpreserved argument might fall upon the defense counsel's shoulders. I'm well over my time here unless there are other questions.
And you were answering our questions, and so
Yeah.
that's our fault for keeping you over. So we'll give you your full rebuttal.
Thank you very much.
All right, Mr. Boyer.
Good morning, Your Honors. Counsel, may it please the court. Daniel Boyer for the state. First, I'd like to address the pretrial ruling under 412. The trial court acted well within its discretion in denying defendant's motion under Rule 403 to admit evidence of another man's sexual abuse of the child victim in this case. Under Rule 412A, the following evidence is not admissible in a criminal proceeding involving sexual misconduct. 1, evidence to prove that a victim engaged in other sexual behavior, or 2, evidence offered to prove a victim's sexual predisposition. There are exceptions to this rule, and defendant argues that the Rule 412 evidence here was relevant to prove that someone other than defendant was the source of the pubic hair that victim brought to police in 2005. But the trial court here found, based upon what evidence it had before it, from a police report that was cited in defendant's motion, that the possibility of the pubic hair belonging to this other man was, quote, remote and speculative.
And let me follow up on my question that I asked of counsel earlier. And that question seems to be a 403 analysis, not a 412 analysis,
That's
right?
correct.
Because as
Yes.
I read 412, it's not the probative nature of the evidence. It's just that there is evidence of that particular thing. So once we have the physical evidence and the defense seeks to introduce evidence of another source of that physical evidence, then we move out of 412, right? And we move to 403. So what you're describing now, to me, is the 403 analysis that the court conducted. Are we on the same
absolutely
page?
right. Yes, and that's how the trial
Okay.
court conducted it. Mhm.
Okay, so and I think this is Judge Luthy's question from before, when we go to the 403 analysis, does it matter that we started in 412? Or is it a straightforward 403 analysis, just as it would be for any other piece of evidence?
It absolutely matters, and I refer this court to State v. Beverly, a 2018 Utah Supreme Court case. At paragraph 56, it reiterates the longstanding principle from Boyd that Rule 412 evidence under the Rule 403 analysis is presumptively inadmissible. So to the extent that the Supreme Court has talked about adherence to the plain language of 403, this issue is still resolved in favor of finding that Rule 412 evidence is presumptively admissible under Rule 403. But in any event, even if we set that aside for a moment, the trial court conducted the analysis properly by determining that the prejudicial aspects of this 412 evidence substantially outweighed any minimal probative value. And it was correct to assess the probative value. That's part of Rule 403, is weighing how probative is this? Well, this wasn't probative under the unique circumstances in which defendant alleged this hair could have been collected. And I take issue with there was inconsistency in the testimony about how long she was at this hotel. Her mother testified that she was missing for only 1 day before police found her. So there's discrepancy there. But I think a more fundamental problem is that the trial court, in making this determination, relied on police report, a law incident report from Brigham City, cited it in its brief, said the defense had it in its possession. It's not in the record on appeal. And to the extent the defendant is challenging the trial court's findings and its mixed findings, there's an absence in the record to make that evaluation, I would say. And so the defendant has deprived this court of adequately being able to assess this evidence. From what we can glean from the incomplete record here, what the trial court had before it, its findings, it was absolutely correct to determine that this evidence had minimal probative value. And we know that the victim had disincentives to lie about this by bringing it to police in the first place to have it tested. She testified at trial that she was convinced that this would lead to a DNA match with defendant, exposing herself to potential repercussions with law enforcement by falsely framing defendant, weighed against any idea that she was somehow using it to frame the defendant in this case. And I'd also point to the fact that she was entering contemporaneous diary entries about sexual intercourse with defendant around the time when there was first sexual intercourse in October of 2003, further supporting and corroborating the victim's testimony on this point.
Mr. Boyer, can I just drill down just a little bit? It's a discretionary action when the trial court undertakes a 403 analysis, right?
That's right.
And are there any, which seems that, based on the facts of the case, based on the court's understanding of everything that's going on in the trial, that we wouldn't necessarily second guess, we as an appellate court wouldn't necessarily second guess a trial court's, when a trial court is undertaking that weighing, that balancing, if they put more weight on, you know, the potential prejudice to the victim versus to the potential prejudice of the defendant.
Right.
That seems like, maybe that's not true, but how do we look at the trial court's balancing under 403, especially given a 412, it's in a 412 context?
Right. So I think we can look at it strictly under the plain terms of Rule 403. We can look at it, okay, what is the probative, did the trial court abuse its discretion where it found that any probative value was substantially outweighed by the unfair prejudice to the victim in this case? And it's not as if we turn a blind eye to all of the prejudice inherent in this evidence once we go to Rule 403. That wouldn't make any sense, and it contradicts State v. Beverly. So we do look to how will this, invade the victim's privacy, and I've cited to a case from this court where it's held that that is part of the analysis under Rule 403 when we're dealing with Rule 412 evidence. We do consider the invasion to the victim's privacy as part of the Rule 403 analysis.
Seems like if we're going to consider that invasion to the victim's privacy weighing on the one side, that if on the other, there ought to be a counterbalance on the other side, that if the state is using the idea that the victim is sexually inexperienced and it's hard to come up with the right terms in this, but innocent, that ought to, there's probative value to showing that she wasn't. And did the trial court get that weighing right here? And secondarily, was that argument preserved?
So that argument was not, did not come up until trial. So as far as the pretrial ruling is concerned, that issue was not broached or brought up because, and really, if we compare this case to Eddington, the prosecutor wasn't using, the prosecutor was not interjecting Rule 412 evidence. Again, Rule 412 evidence is evidence offered to prove that a victim engaged in other sexual behavior or evidence offered to prove a victim's sexual predisposition. Saying that Sadie was a little girl, that she was a little 12-year-old girl, is not sexual evidence. It's not Rule 412 evidence. The defendant points to that as somehow opening the door to Rule 412 evidence, but compare that to Eddington, where the prosecutor's opening stated that the defendant took the victim's virtue. Couple that with the victim's testimony in Eddington, that she wasn't the type of girl who allowed men into her bedroom. This court held that opened the door, but there was no evidence of 412 interjected by the prosecution, using it as a sword. Talking about Sadie as a pseudonym, talking about Sadie's age as being 12 years old, that was an element of the crime. The state had to prove beyond a reasonable doubt that the victim was under 14 years old when each of these crimes were committed. And furthermore, regarding prosecutor's closing argument, prosecutor didn't bring up the pubic hair in opening, prosecutor didn't bring up the pubic hair in closing argument. It was only after the defense made an insinuation in its closing argument that somehow this hair had been planted, that the state responded in rebuttal that it was certainly defendants, because why would Sadie have brought it to police in 2005 to get a DNA match, believing that it would match with defendant? So this really wasn't.
Did the comment, the hair's got to belong to someone, that was referenced, was that in rebuttal?
That was in the prosecutor's rebuttal, that's right. So any slight probative value from this evidence was substantially outweighed by unfair prejudice. It had a strong tendency to invite character inferences about the child victim's sexual predisposition as a 12-year-old when she could not consent to sex to begin with. That was entirely irrelevant to the crime's charge, and it would only inflame, mislead, and distract jurors from the deliberative process that they're to engage in.
I do have one question, because it seems to me perhaps this matters in this circumstance. So you just use the word predisposition, right? A sexual predisposition. But I don't think anyone would dispute that the prior incident that had occurred was a criminal act undertaken against a minor who's legally incapable of consenting, right? And so it's not quite the same in my mind that this evidence would demonstrate that she had any predispositions of any kind, rather that she was a victim of a sexual crime, and we know that the individual there was criminally prosecuted for that crime. So it seems to me that it's just somewhat different here. It's not like where we have an adult and we're trying to talk about sexual behavior in a way. What I take the defense to try to be introducing is actually evidence of a crime that occurred where she was the victim, and I'm just not sure that brings to the forefront anything about her behavior, especially if there's some limiting instructions given by the district court that it can only be discussed in the terms of that she was a victim of a sexual crime. Does that distinction matter here?
I think it does, and it further confirms that this wasn't admissible, because if the defendant is now arguing that this evidence should have been admitted to rebut the idea that she was sexually innocent, well, that means that they're offering it to prove her sexual disposition, that she was not sexually innocent. So it's inadmissible for that purpose. To the extent that they've argued it's admissible to prove an alternate source for the pubic hair, that's a different analysis, certainly. But that was the pretrial ruling, and that door was never opened. All the defendant has argued regarding Mother's testimony at trial and how it allegedly opened the door was with regard to opening the door to this act to somehow rebut the idea that she was sexually chaste. And it is patently inadmissible for that purpose. But with regard to the pubic hair incident, it's inadmissible because its probative value is low, given the unique circumstances of this hotel incident, compared with victims' confidence that it would provide a match with defendant when she provided it to police. And analyzing, the prejudicial aspect of this evidence, it's substantially outweighed any minimal probative value. Even if this evidence had been admitted, that the victim had been sexually abused by another man 5 months before defendant raped her, it would have only served to distract jurors. It would not. There had no reasonable probability of it proving that this other man was the source of the pubic hair, given the circumstances that I've already described in the hotel room, let alone a reasonable probability of providing defendant a different outcome at trial. That's because the evidence of defendant's guilt was strong. This wasn't simply a he said, she said case. Defendant himself made damning admissions during trial, including that he snuck into grandmother's basement late one night with the victim, asked her if she was ready to have a sexual relationship after she asked him if he was ready to have a sexual relationship, admitted to flirting with her, thinking she was cute, kissing her. So his own admissions at trial were damning, but there's also the corroborating testimony from Mother, who testified that she found these two in grandmother's basement late one night with the lights out. She switched on the light, found defendant in only his boxers and socks. He pushed past her, shoved past her, ran up the stairs and fled out into the night. And Mother had no incentive to lie to police about this incident at the time. She didn't even know who defendant was at this point. So defendant had more incentive to lie at trial about this, given that he was facing these convictions. And defendant's theory at trial was that the victim, who was now a 32-year-old woman by the time she was testifying, somehow was still jealous and seeking retribution against defendant for breaking up with her 20 years earlier to be with another girlfriend. The girlfriend testified at trial that after police were called in 2005, she called defendant, let him know about it, and they met up at a Walmart. She provided him a change of clothes and didn't tell her where he was going, but then 2 days later called her from Mexico. His activity of traveling through Mexico, staying out of Utah, traveling, and then moving into the southern U.S., finally being apprehended in Georgia, all support consciousness of guilt, that he was fleeing out of consciousness of guilt. And the girlfriend also testified that she saw the victim approach defendant at a soccer park after this sexual conduct had occurred. And victim called out to defendant, and defendant acted like he didn't even know her. But defendant himself admitted at trial that he knew her by that time, certainly, and he admitted he had asked her if she wanted to have a sexual relationship in the basement of grandmother's house. Unless there are further questions at this point,
I don't see any.
I'd
Thank
ask the
you.
court to affirm. Thank you.
All right, Mr. Thompson, your rebuttal.
Okay, so I'm gonna try and move through these points quickly. The state cites to Beverly as suggesting that the presumption is for inadmissibility when we're talking about a 403 analysis in terms of a 412 case. Beverly is wrong just for the exact same reason Boyd is wrong. Beverly cites to Boyd, that's old case law. So that citation, I think, is wrong for the exact same reasons that Boyd is wrong. In fact, I think Boyd is cited right below in the footnote there.
What about State versus Bravo? That's a 2015.
Bravo would be 2015, still predating 2018. I think this problem was in a lot of cases. I think it's only been more recent that the courts have moved away from infecting 403 with these other analysis. And sometimes we get it wrong, and we're trying to make these cases better. We're trying to make them clearer. We're trying to be more faithful to the rules themselves so they can be applied in consistent ways. State then talks about Sadie's disincentive to lie. As a 13-year-old, the state is giving her a lot of credit for in 2004 and 5 for knowing what's going to happen to this evidence that she presented to the police. I think that is a stretch to say that she would have known that if she had provided the police with a pubic hair that she had actually collected from Edmundo or from some other source that wouldn't actually end up in a DNA match, that would get her in trouble. I think that is a stretch. I want to focus most of my time on your comments about consent, because Eddington is a different kind of case, and 412 is primarily directed at cases where consent is the question at trial, and that's why the prejudicial impact of prior sexual conduct is so significant in those cases, because of old-fashioned and outdated views about sex. Juries might have unfair prejudices to a victim who's saying, I was abused in this case, I did not consent to this sexual activity, and then evidence of prior instances where they did participate in consensual activity comes in. That is what 412 is about. But 412 is written in broad language and has an impact on all cases involving sex, including cases with children. But the point and the emphasis and the protections are very different when consent is not in the picture. As Judge Oliver pointed out, juries aren't necessarily going to say, well, yeah, she had been abused in this other instance, so therefore she was or wasn't abused in the second instance. That's not the same kind of problematic prejudicial inference that a jury might jump to as if we were dealing with an adult. But the reason I bring this up is that it matters a lot in children's cases. 412 has a different importance in cases involving children because of these inferences that the jury will give to a victim about knowledge about sex, about all these other things that then 412 becomes even more important for the defendant. The exceptions to 412 become even more important for the defendant because he's not trying to prove this is someone who has a sexual predisposition and will engage in sex anytime it's offered. He's trying to prove that this witness may not be believed in this instance because there are other sources, not only of physical evidence, but of knowledge and of other reasons. And that's why the protection of 412 apply differently in children's cases. Not that it doesn't apply at all, but the considerations there are very different. And so the threat of inflaming or misleading or distracting the jury that would apply in adult cases don't necessarily apply in the same way in children's cases. Okay, and then finally, the state talked about the prejudicial or the lack of prejudice to the pubic hair. And it's very often the case, the state focuses on evidence that is sort of supports or bolsters the outcome, but not as to elements. Okay, so the state focused on the other evidence that was presented. For example, the instance where mother discovered someone who she later identified, 20 years later identified as a 40-year-old Mr. Hernandez, the person that she saw in the basement. But in that instance, Sadie had her clothes on. There was not an allegation of the rape of the child occurring at that instance. So his presence there might have been supportive of some of the other crimes or something else, lewdness perhaps, but it does not bolster the idea that sexual intercourse occurred. And this is a 10-year to life sentence that Mr. Hernandez is serving right now. The fact that they knew each other, that they had interactions, that he saw her at a soccer game, those are very, very, very slightly probative to the fact that he's convicted of sexual intercourse, and not probative of the elements whatsoever. But the hair is, and it's significant in a very, very significant way, because access to pubic hair means access to genitals. And exposure of genitals or access to genitals gets you a lot closer than knowing somebody, than kissing, than being found in the same place. And it's even more probative than talking about whether or not they want to have sex. It is the access to the genitals that is really significant here. And that inference is why the introduction of the pubic hair is so important in the case. Because it takes away all of the he said, she said component of the case and makes it about a forensic piece of evidence. And when it's attributed both by Sadie and then by the prosecutor to the specific defendant, the defendant has no way, under the circumstances of the court's ruling, to rebut that, other than to say that's not mine. I don't know where she got it from. And I can't tell you anything else. That is the unfair prejudice and the likelihood of an outcome where otherwise it is very, very a he said, she said case when it comes to the elements of the offense.
So just out of curiosity, you think the court should have ruled it inadmissible? You know what I mean? Like,
one or the other, I think.
okay.
So if
Either allowed the defendant to talk about it in the context of how it could have been discovered.
how else it could have been presented, that's right.
Or just kept it out.
Or keep the hair out. I mean, I don't think there was a basis to keep the hair out. I think under 403, the victim's statements and justifications for where it came from probably met the standard of having it be relevant and admissible. So I don't think the court could have kept it out.
And
You
the
just said
defendant
403,
even
did you mean 402?
I'm sorry, 402, under the
Or, I'm
relevant
sorry,
standard. Yeah.
And 412.
Well, are you saying that, actually, I hadn't thought about that 412 would have excluded the hair? I don't think so, because
I don't think
because
so.
it was evidence of this crime,
Right.
or at least purportedly evidence of this crime. So it was coming in, I think.
And did defendant even make that motion? Like,
I don't
I
think
don't
so.
think so.
I don't think he moved to exclude it, and
It was
I don't
coming-
think it would have been
Because
granted.
it was coming in.
Yeah, I think it was coming in. I think the burden of demonstrating admissibility was quite low for that, and the state met that burden. I think everyone understood it was coming in. But that same low burden was not provided to the defendant when he had a response. Instead, he had the opposite, the inference, the presumption that he could not respond to this evidence the state was presenting. And that's the unfairness of the case, is that they allowed the evidence to come in with the significant impacts associated with it and then prevented the defendant for essentially, in my opinion, no good reason when we're doing
What
that
do we-
analysis.
Under the 403 analysis, on the one side is the probative value, and the court gave it low probative value. And as Mr. Boyer noted, the evidence that the court relied on to give it no probative value is not in the record. How can we adjust the probative value side of that equation when we don't have the evidence before us that the district court had?
By assessing the arguments that are in the record. The evidence that is in the record is that there was this incident just months before. That brings the probative value up. That she had access. You know, the description that was presented to the court was that there was sexual activity, including an attempt to add vaginal intercourse. That raises the probative value, the likelihood of her access to that area and access to a pubic hair, that increases it. The court's focus on these other things, I think, even if they were admitted, wouldn't overcome that, in my mind. I think he's got the balancing quite wrong. But the fact that it's not even in the record means this court can look solely on the information that is before the court. And the balance, in my mind, is quite clear. If we're talking about, is it relevant? Yes, it is. Does it have probative weight? It certainly does in response to the way the state presented its case. This is forensic evidence that proves Mr. Hernandez committed this crime. And the risk of unfair prejudice, I think, was low. The court could have limited the information that came in about Edmundo. We're not saying that every detail had to come in. We're not saying that everything about her behavior or her participation therein or her love for the person. We're not saying all that came in. But when we're talking about an alternative source of physical evidence that the state used to prove that Mr. Hernandez committed this crime, the probative value is extremely high and the risk for prejudice, I think, was low.
It would have, if the evidence about Edmundo would have come in, then it does seem like evidence of the investigation into Edmundo, and was there time for her to discover the pubic hair on her own before it being examined and all of those things, that there would have been this other kind of trial within a trial, as we sometimes say, that would have been going on at the same time. What do we do with that?
I mean, I think there could have been. But again, each of those details would be subject to their own 403 analysis. That's not really before the court right now. And I think because of the lack of information in the record about those details, we can't engage in that. But I think even if the information had been severely limited about what was available and what wasn't available in that time frame, the point to the defendant is the jury was entitled, and he was entitled to have a jury consider the idea that this forensic evidence could have come from another source, especially in light of the inconclusive DNA result. I mean, that is the kicker here. I'm way over my time, but I'm maybe unnaturally preoccupied by how damaging inconclusive DNA results can be in a case. And in this case, they certainly were very, very damaging because the state got to use all the benefit of the inference, and the defendant got no benefit from being able to point the other direction. That's all the time I have. Thank you very much.
All right, thank you. We appreciate your briefing in this matter as well as your oral arguments today and answering our questions. We will take this matter under advisement and issue a decision as soon as we were able to. And with that, we will be in recess for today. Thank you.